friends, welcome to Tarunayas. Today we will be discussing editorials from The Hindu and the Indian Express of 2nd of November. 2nd of November 2022. So let's start with the editorial. I have taken this editorial from the Indian Express. It is about the role of the governor. You can relate it with your general studies paper 2, that is power and functions of the governor, state legislature and union executive. So this is the editorial titled Rajbhawan, Rajdharma. So recently, if you have been following news for a long time, then you might have noticed that there is always some day or the other there is a tussle between the chief minister of between the chief minister of Kerala and the governor. So ever since there has been a change in the ruling party at the center and the state, the position of the governor has been politicized, and this first started since 1970s. So from 1970s onwards, we can say that there is always a tussle between the governor and the chief minister, or you can say the council of minister. So why this tussle is prevailing? Why there is no separation of power between the governor and the chief minister? Or what kind of a role does governor play? Or does he have the power to exercise unfettered jurisdiction over the powers and the functioning and administration of the state? So we would see this in the article, but first have a look at the polity of India. So at the time of the independence, that is 1947, the Constituent Assembly had adopted the parliamentary model. Now this parliamentary model was based upon the Westminster model. It is known as the Westminster model because it was first originated in the region of the Westminster, England. So that is the reason why it is also known as the Westminster model. So India adopted the parliamentary democracy and also representative democracy. So in the post-independence India, you would study about how basically our former home minister, that is Sardar Vallabhbhai Patel, had endeavored to unify India, had endeavored to unify the princely states into the Union of India, so as to have a country as we see today. However, the constituent scheme of our country does not make states as the subordinate unit to the Union. They have the equal power, and they are the autonomous. Not completely autonomous, but some of the functions have been delegated to them. That means there is a separation of power between the union and the states. However, the union exercises jurisdiction over some of the subjects of the state, and this is under the exceptional circumstances or extraordinary or special circumstances. However, the position of the governor, as according to the Supreme Court verdict in 1970s, is a constitutional post. And it is not a job under the union government or the state government. However, the governor, according to some of the powers that have been given to the governor, works as basically a kind of an agent, like not exactly as an agent, but connecting link should be the more technical and the appropriate term. So governor functions as the connecting link between the union government and the state's government. However, in the recent times, the position or the office of the governor has been politicized. So if we look at the office of the governor, the office of the governor has been borrowed from the 1935 Government of India Act of 1935 that was promulgated during the British colonial rule. The appointment of the governor has been borrowed from from Canada. So the office of the governor has been borrowed from Government of India Act of 1935, and the appointment, the way the governor is appointed by the president, has been borrowed from the Canada model. So these are some of the basics that I have discussed with you about the position of the governor. We will later on in the subsequent discussion of the editorial, we will discuss about the powers of the governor, the discretionary power of the governor, which is constitutional as well as situational. But as for now, we will restrict ourselves to this. Let's move on and see what the context is. Now, like I said, there is always a tussle between the Kerala governor, which is Arif Mohammed, Mr. Arif Mohammed, and the chief minister of the Kerala. Alright, so what has happened? The finance minister of the Kerala had made a remark on the security provided to the vice chancellor of the Uttar Pradesh. Now he had made a certain remark. According to the governor of the Kerala, the minister has violated his oath. The minister has violated its oath, and therefore, according to the Kerala governor, he must cease to enjoy the governor's pleasure. We will discuss what this governor's pleasure or the doctrine of pleasure means, which is applicable to some of the offices appointed by the governor and the president of India. So according to the Kerala governor, he must cease to enjoy the governor's pleasure. So therefore, the Kerala governor seeks dismissal of the state finance minister. So these two things are linked: the dismissal of the state finance minister and the governor's pleasure. Now, how these two things are linked? So first, let's talk about the doctrine of pleasure. So we know that India has bicameralism, right? So there is union government and there is state government. So we have separation of power according to the 7th schedule. The 3 lists are there, and then there is a reserve list, which is over which the parliament has the complete jurisdiction. Now what happens? The governor of the state appoints the chief minister and the other ministers of the council of minister, right? So the appointment is done by the governor at the level of the state, and appointment is done by the president at the level of the union. However, one thing needs to be clear, that governor does not have the choice to appoint anyone. There are certain provisions in the constitution and as well as the conventions which have been formed over the years of governance governing this independent country, that governor does not, by his whims and fancy, can choose anyone as a chief minister. The person who holds the largest majority should be appointed as the chief minister, and the other ministers of the council of minister or the cabinet ministers are appointed on the advice of the chief minister. So that means the governor does not have the complete jurisdiction over the appointment. He has to work in accordance with the aid and advice given by the council of minister. So when it comes to the doctrine of pleasure, it's not the sole pleasure of the governor. Rather it is the aid and advice of the council of minister. All right. So I hope this is clear. So far so good. Let's move on now. Let's look at how the writer has started this article. So till now I discussed some of the basics of polity with you. Now we will discuss some of the important points of the writer. So writer basically starts his article by quoting Miguel de Cervantes, and which says that the good governor should have a broken leg and should be kept at home. The point here is the writer by quoting Miguel de Cervantes wants to say that the governor does not have a complete autonomy over the administration of the state. He works according to the aid and advice of the council of minister, right? Some of the constitutional discretion has been provided. There are certain situational discretions to the governor. However, the governor does not have the unfettered power to administer the state, right? So this is what the writer wants to say. So the point is, governor is a titular head. What do I mean by the titular? That means only a title is given. Only a title is given. That means, however, but the de facto ruler, there are two terms, the de jure and de facto. The de jure means the titular head, the nominal head. That means सिर्फ नाम के लिए. So governor is a titular or a nominal head. However, the real power rests with the chief minister or the prime minister in case of the union government. So president is only titular, governor is only titular. The rest of the power the power rests with the chief minister or the president, whatever the case may be. Right. So governor is a titular head. So this is what the writer wants to convey. The second thing that the writer says, that the primary role as a sagacious means as a sagacious counselor was to be consulted, warned and to encourage. That means to work in the good for the good of the state. So the advices, the encouragement, the warning, etc., etc., all the role which is played by the governor should be for the good governance of the state. Right. That means the writer, by quoting these two examples, wants to say that the position of the governor, which has been so politicized in the recent years, was not how the Constituent Assembly had designed the role of the governor or the prime minister or the president. Sorry. So the governor office basically signifies an assault on the parliamentary democracy at its best and constitutional despotism at its worst. Now, what the writer has to say with this, that basically the governor's office does not have power per se. So having a governor at the state is sort of having a governor who does not function according to the provision of the constitution is sort of an assault on the parliamentary democracy. Now we would discuss some of the important judgments of the Supreme Court as well, so as to see that how the Supreme Court has interpreted the role of the governor at the state and how it led to and how the role of the governor has come into the highlights of being either not in the favor of the ruling government in the state, but in the favor of the party that he or she is associated with. So that is the level of politicization of the role of the position of the governor. Now let's look at some of the constitutional provisions which governs the position of the governor. The first article is the Article 163. Now, Article 163 says that the Council of Ministers headed by the Chief Minister is to aid and advise the governor. Right. The second article that deals with the role of the governor is the Article 164, which says that the discretion of the governor is not the sole discretion of the governor. Rather, it is the advice of the Council of Ministers that is to be strictly followed by the governor. So let's look at some of the discretionary powers of the governor. The first discretionary power of the governor, which is constitutional, that means as per the provisions of the constitution. There would be some articles mentioned in the constitutional which would give governors this kind of power. So the first power is the reservation of the bill. Now what happens when the state legislature passes a bill, the governor has this discretion over it, whether he or she wants to reserve that bill for the president or not. Sometimes what happens, if there is a bill which is kind of compromising the position of the state or compromising the position or intercommunication between the state and the union government, so the governor does have the constitutional discretion to reserve that bill for the president. Now once the bill is reserved for the president is going to overlook the passage of the bill. That means the president will have the power to give assent to the bill. So this is the first point that we discussed. The second point is the president's rule. So according to Article 356, now Dr. B.R. Ambedkar said that Article 356 is going to be used sparingly. However, post 1980s we did saw we did saw that the article 356 has been used so many times for some or the other political reasons, So what does this president's rule means? There are certain conditions which have been laid down either by the constitution or by the convention, which says that the governor has to send report to the president if the president's rule can be applied on the state or not. So this is article 356. Now, according to the 7th Constitutional Amendment of 1956, the governor can be given the additional charge of the adjacent or the other state or the union territory. Now, when the governor has the additional charge of the union territory or another state, he or she has the sole discretion or the power to administer that state, and the council of ministers are not going to interfere into that matter when the governor has the additional charge of the union territory. So this is the third point, the third constitutional discretionary power that has been given to the governor. There is one important point to be noted here, that governor does have the constitutional discretionary power. However, no such power exists. No such power is with the president. So president does not have any this kind of power. However, the governor has. Let's move on to the fourth point. The amount which is payable as the royalty to the sixth scheduled state. And what are these sixth scheduled state? So there is one important thing that I would like to tell you guys here, that you have to thoroughly read Lakshmikant, and you have to remember or sort of memorize all the schedules of the Indian Constitution, that which schedule deals with what provisions. Some of the important articles of the Constitution you should remember or memorize, because they come in handy when you want to quote in your answer. And some of the important constitutional amendments should also be on your tips. For example, the 7th Constitutional Amendment Act of 1956, it made a lot of change in the Indian polity, and one of those changes was that the governor can be given the additional charge of the state and the union territories. I think this was probably done after the bifurcations of the many states, and also the changes that the Indian state have undergone since independence. So we were talking about the 6th schedule. So 6th schedule has 4 states: Assam, Meghalaya, Tripura and Mizoram. So these are the 4 states under the 6th schedule. So the amount which is payable to the government of these 4 states as royalty to the mineral explorations in the state is decided by the governor. And this is the constitutional discretionary power to the governor. The last point is that the governor has the constitutional discretion to seek information from the chief minister. Alright. Now let's talk about the discretionary power, but in certain situations. So this is what the situational power of the governor means. When it comes to appointment of the chief minister. Now this appointment of the chief minister has always been a bone of contention between the governor and the parties and the various political parties. For example, if you look at the case of the Karnataka, if we look at the case of the Maharashtra, and it was because of the appointment of the chief minister that plays such an important role when it comes to the politics of the state, that in 1980s, the Indian Parliament had to pass one act which is known as the Anti-Defection Act. So we will not discuss this Anti-Defection Act in detail, but we are going to restrict ourselves to the governor. So appointment of the chief minister is a situational power of the governor. The governor is to decide. However, it's not like governor can appoint anyone as the chief minister. Only the person who holds the majority in the state legislature, who can prove the majority at the floor test. Now what is this floor test? It is to see whether the ruling government enjoys the majority of the state legislature or not. So if they enjoy the majority, or more appropriately or technically speaking, the confidence of the state legislature, right? So if it enjoys, then it is the ruling government, and the person who is the leader of that ruling government is appointed as a chief minister, and whosoever the person that the party decides. So there are certain steps which are given by the Punshi Commission. You can refer to Lakshmikant for some of the important recommendations by the Punshi Commission and the Sarkaria Commission of 1970s. So these two commissions are very important when it comes to the role of the governor. So some of the recommendations were given by the Sarkaria Commission and the Punshi Commission regarding the role that the governor plays in the state. So appointment of chief minister. The second is the dismissal of the council of minister. However, we had already discussed the doctrine of pleasure. We had discussed that the Kerala governor Arif Muhammad is seeking the dismissal of the state finance minister. We also discussed that why is he seeking the such dismissal. However, he can only seek. He cannot dismiss the minister. He cannot dismiss the minister because the dismissal, he can only advise the chief minister to dismiss the minister, or the minister can himself or herself resign. The governor does not have this power that he can dismiss the minister. He can advise the chief minister, and chief minister has the power to dismiss the minister, which is going to create only a void in the council of minister, which can later on be filled, right? So here you have to understand two things, which is the collective responsibility and the individual responsibility. So you can look for these two topics in Lakshmikant. And dissolves of the state assembly. So depending upon the situation, the governor can dissolve the state assembly. However, a point is to be noted here that the governor cannot dismiss the state assembly as per his will, his or her will. It is on the, according to Article 163, it is on the aid and advice of the chief minister and its council. That means the council of minister is going to advise whether the governor would dissolve the state assembly or not. So if we look at the powers which have been given to the governor, he can only function on the aid and advice of the chief council of minister headed by the chief minister. So the writer wants to say that if we look at the role recently being played by the governor, then he or she they're exceeding their role, which is a kind of a jolt to the constitution scheme. The separation of the power that have been decided, and the roles, the separate or individual roles that have been given to the constitutional offices. Now let's look at some of the important judgments of the Supreme Court, which talks about that how the governor has to play the role. So the writer has mentioned three important judgments. The first is the NCT Delhi versus Union of India 2017. In this judgment, so there was a tussle between the chief minister, council of minister headed by the chief minister of Delhi, that is Arvind Kejriwal, and the then lieutenant governor of Delhi, Anil Bajlani. Now it has been changed, but this was the case of the 2017 when the union executive also passed the NCT bill, which seek to dilute the position and the power of the council of minister. However, in this particular case, the Supreme Court held the real power rests with the elected council of minister. That means Delhi, this is a special case of Delhi, but however, if we look at the judgment of the Supreme Court, then it says that the power rests with the elected council of minister and not with the nominated representative, right? Because India is what? India is a representative democracy, so the power should rest with the elected people. So CGI in this particular case held that India had adopted the Westminster model of the government, means that the real power rests with the government and the governor has to be just a nominal head. This is the first case. Now we talk about the second case. The second case is the Nabam Rebia case of 2016, in which the Chief Justice has held that the exercise of the executive power of the governor is by and large notional. That means, according to Article 163, he works on the aid and advice of the Council of Ministers. The third important case that the writer has quoted in his article is the Keshwananda Bharti case of 1973. Now, the Keshwananda Bharti case is very important because the Supreme Court Supreme Court evolved a doctrine which is known as a basic structure doctrine. Now, basic structure has not been mentioned anywhere in the Constitution. It has not been defined. However, according to the judgment of the Supreme Court, it's a constantly evolving phenomena. That means depending upon the situation and the condition, the Supreme Court, after interpreting the Constitution, would advise or would decide that what constitutes the basic structure of the Constitution. So, according to the Keshwananda Bharati case of 1973, the republican and the democratic form of government is one of the basic structures of the Constitution. And in the republic, when we say republic, there are two terms of which meaning should be clear to you, that there is republic and there is monarchy. There is what? Monarchy. So monarchy, like we had in case of the England does have a democracy, but the monarch is what? The titular head, or the nominal head of the England is the king of the England or the prince of the England. So there is monarchy. For example, in Bhutan we have monarchy, in Thailand, right? We have monarchy in Saudi Arabia. Although democracy is there, but it's just for the name, for the sake of purpose, right? But it does not fulfill the real characters of the democracy. England is an exception though. So there are two terms, the republic and the monarchy. So republic means that the head of the state. There are two terms now important, the head of the state. There is head of the state, and by state here I do not mean the states of India, and by state I mean here according to the Article 12 of the Constitution as defined, the state as defined by the Article 12 of the Constitution, and also the political definition of the state. So state does not imply here the states of India, however the state as a political entity. So the head of the state is the president, and in case of the monarchy, the head of the state is the king and queen of that particular country. When we say republic, the head of the state is the president who is elected. Now election can be direct or indirect, right? So these two terms are clear now, the head of the state and the head of the government. The head of the government is the prime minister, right? So these terminologies are clear to you now. So I have cleared the difference between the republic and the monarchy, and the head of the state and the head of the government. So according to the Keshwananda Bharati state, we do have the republic and the democratic form of the government, which is the basic feature of the country, basic feature of the Constitution. Thus, this cannot be exceeded. This cannot be exceeded. And the role which is played by the governor so far has been exceeding. According to the writer says that Kerala governor has exceeding his role as a governor, right? So another Supreme Court judgment that the writer has quoted is the Shamsher Singh versus the state of Punjab of 1974. In this case, the apex court said that in parliamentary form of democracy, the governor should ideally behave just like a British monarch, right? Because British monarch does not have any power. They only have the prestige because they used to be the ruler of the country or the monarch. However, the real power lays with the Parliament of the England or the UK, right? So that's it for today. Thank you so much for watching Tarun Eyes. Have a nice day.